الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله صلى الله عليه وعلى آله وصحبه وسلم تسليما كثيرا عما بعد. So today inshallah ta'ala we'll pick up from where we had stopped last week, where we discussed the matter regarding al-qada. So matter regarding al-qada, and we had reached a bab where he mentioned bab fi bayan dawa'i wal bayyinat. So we'll continue discussing those matters according to what is mentioned here by the author وفقه الله. أيوة.
السلام عليكم. بسم الله والصلاة والسلام على رسول الله. قال المؤلف رحمه الله. Chapter 6, page 725, title Claim and Evidence. The term claim refers to the act of requesting or demanding something. Allah exalted be He says, and for them is whatever they request or wish. Surah Yasin, ayat 57. Jurisprudently, the term claim refers to the act when a person demands something in the possession of another person or in his ability. As for the evidence, it refers to any sign indicating one's right, such as witnesses and oaths. Imam Ibn al-Qayyim, may Allah have mercy on him, said, in the Sharia, clear evidence refers to whatever clarifies and manifests any right. Allah, exalted and glorified be He, has made rights clear with signs and indications signifying and leading to them. So whoever ignores those signs and indications is in general wastes a lot of rulings as well as rights.
Yes, so the author here, rahmatullahi ta'ala, discussed concerning this bab, discussed concerning the matter regarding ad-da'wa, and also clarifying what is al-bayyinat. So he mentioned the meaning istilahan as to what is said to be ad-da'wa, and also what is said to be al-bayyina amongst the fuqaha. Then, so first to clarify those matters, then started discussing the different aspects regarding people making claims and how one can substantiate their claims. Aywa.
The difference between the plaintiff and the defendant is that the former is the one who is released when silent, does not claim, while the latter is the one who is not released when silent, as he is claimed against. In order to decide on the validity of the claim or the denial defense, each must be from a person who has the freedom of action, i.e., must be a free, major, and legally accountable person.
So that's okay. So of those things we're going to say, mention that in those claims that you have the matter which is the da'wah, the thing that is being claimed. Then you have al-mudda'i, the person who's making the claim, and mudda'i alayh, and the one who the claim is being made against. Then also with this matter, he discussed regarding concerns sihhat al-da'wah, for a person da'wah to be considered to be valid, that there are certain things that should be in place. And of those, that a person should be, of he mentioned, hur, mukallif, rashid. So anyone making a claim that they should fulfill these basic requirements. Aywa.
If two persons claim for a particular property that is already in the possession of one of the litigants, then it belongs to the person who has it, provided that he swears an oath that it is his. In this regard, the litigant who is in full possession of the property is called the ingoing, while the one who does not possess it is called the outgoing. However, if each of the two litigants submit proof that the property is his, the property is to be given to the outgoing party, the one who does not possess it. This is based on the hadith narrated by Ibn Abbas radiallahu anhu as a marfu' hadith. In this hadith, the Prophet ﷺ said, if people were to be given what they claim without proving their claim, then some people would claim the life and property of other people. The oath is to be taken by the defendant in the absence of any proof against him. Related by Imam Ahmad and Imam Muslim. Moreover, the Prophet ﷺ said, proof lies on the plaintiff and the oath is to be sworn by the defendant. Related by At-Tirmidhi. Thus, the two hadiths indicate that the plaintiff is the one who must bring proof substantiating his claim. If he brings it, the decision will be in his favor. They also indicate that the oath is to be taken by the person who denies the claim, i.e. the defendant, when the plaintiff does not have proof substantiating his claim. In this case, the majority of scholars say that the property belongs to the one who already is in full possession of it, i.e. the ingoing party. Those scholars are of the view that the hadith concerns the case in which the one who is in possession of the property does not have a proof, thus his possession of this property next to the proof will be stronger. It is worth mentioning that the opinion of the majority of the scholars has more right to be followed. However, when the property is in the possession of neither, then each is to swear an oath that it does not belong to the other, and the property is to be equally divided between them. This is because they are equal in their claims and none of them have proofs to outweigh those of the other. However, if there is an apparent sign indicating that the property belongs to one of them, it is to be considered in the decision. For example, if two spouses litigate over the clothes and such like of the house belongings, then whatever fits a man is to be given to the husband, and whatever fits a woman is to be given to the wife, and whatever fits both is to be given to both.
So that's concerning that bab, as you mentioned, the making of claims and how to approach this matter. We mentioned two scenarios or different scenarios. One regarding the person who both are disputing about an item or a thing, that the one who makes the claim, whoever has the item, that the one making the claim is for them to produce the bayyinah, and the one who's made against, then for them to make al-yamin, which is for them to take an oath, and the decision would be made accordingly. Then he mentioned a case, if there's no one, the item is not with anyone, then for the judge then to see as to what is best regarding what is more appropriate for one over the other, or both sharing of the items. Then he discussed, then we'll finish with that bab. We go to the chapter that follows.
Bismillahi wa salatu wa salam ala rasulillahi kalama alif hafidahullah. Chapter 7, title Testimony. Testimony in Arabic refers to seeing, since the witness informs about what she has already seen and known. It is a controversial matter among scholars whether the witness should begin her testimony with saying, I testify, or I have testified, or not. In this regard, there are two views. The first is the well-known view maintained by the Hanbali scholars, namely that it is obligatory to say such words when testifying. The second is one of the views reported to be maintained by Imam Ahmad and a group of scholars. They maintain that it is not obligatory to begin one's testimony with I testify or the like. This is the same opinion adopted by Imam Taqiyuddin ibn Taymiyyah, his principal Ibn al-Qayyim, and other Muslim scholars.
What is it, principal or student? I said principal.
Sorry, disciple. I don't know.
Disciple. Okay.
Hey,
so we mentioned in starting this new chapter that he mentioned shahadat, which is regarding things of witness. Then he mentioned that what is shahada. Then he mentioned the case regarding that of the ulama, or a khilaf between the ulama, as to the person who's bearing testimony to something or a witness to something. Does the person need to say ashhad or ashadtu or shahidtu? So ashhad or shahidtu, is this a must to be said? Then he mentioned there's two aqwal of the ulama, says yes, it has to be said. Where the person said, no, I be a witness to something, or they mentioned the second opinion, that's not the case, that it doesn't have to go with that word specifically. And that's the case of some of the Hanabila, amongst them Imam Ahmad and also Ibn Taymiyyah and Ibn Qayyim have taken that view.
Shaykh al-Islam Ibn Taymiyyah said, it is not a prerequisite of testimony to say, I testify. This is the same opinion adopted by Imam Ahmad and others, and it has not come to my knowledge that there is a contrary legal text in this concern. Moreover, none of the companions of the Prophet ﷺ or of the companions' successors have stipulated saying such words when testifying. Imam Ibn Qayyim says, according to the sound view of the majority of Muslim scholars in this regard, informing about what one has witnessed is in fact a testimony. That is to say, it is not a condition for the validity of the testimony to say, I testify. Rather, whenever the witness says that he has seen such and such a thing, or that he has heard such and such a thing, and the like, this is regarded as a valid testimony. In addition, there is no text either in the glorious Quran or in the Sunnah stipulating that the witness is to say, I testify, when bearing a testimony. Furthermore, none of the companions of the Prophet ﷺ is reported to have stipulated saying so when testifying, or can it be concluded by means of analogical deduction or inference. Further, the numerous proofs of the glorious Quran, the Sunnah, and the statements of the companions and the Arabic language assert that it is not required to say such words when testifying. It is a collective duty to undertake testimony in matters other than the limits set by Allah, exalted be He.
So is that saying that you don't have to say specifically?
It doesn't say specific. There's no test. There's no text like Quran or Sunnah Ijma that a person has to say when being witness shahidtu or ashhadtu. Does not to say that. So it's something maybe that's something that some of the fuqaha have mentioned, but there's no explicit text on that matter. That a person becomes binding to be followed. That's ijtihad of some of the ulama. That's the first matter. And the next matter discussed concerning the hukum of shahada. Aywa.
That is to say, if someone assumes the responsibility of testifying, it becomes sufficient and the rest of the Muslims are not to be accountable, since the purpose of testimony has been accomplished. If there is only one person to do so, then it is personally obligatory upon him in consideration with what Allah exalted be He says, and let not the witness refuse when they are called upon. Surah Al-Baqarah, ayat 282. That is, if witnesses are asked to assume the responsibility of testifying to what they have witnessed, they are to offer their testimony. The general meaning of the verse implies both assuming the responsibility of testifying and offering the testimony itself. According to Ibn Abbas and others, the above mentioned verse means assuming the responsibility of testifying and declaring testimony in front of a judge or a court or deliberative body or those in authority. Since necessity requires legal testimony for confirming the rights of people and the concluded contracts, testifying becomes an obligation like enjoining what is right and forbidding what is wrong.
Yes, that's a hukum that he mentioned in general, that in cases it is fard kifaya, and in general, then he mentioned like the definition of fard kifaya, which ulama mentioned this is a more precise definition of fard kifaya. إذا قام به من يكفي. So they mentioned that fard kifaya, إذا قام به من يكفي, that if the suitable amount of people that is established to carry out the act, that becomes the sin is raised from the others. So that's concerning general regarding shahada, either fard kifaya or in some cases fard al-ayn. Aywa.
As for declaring testimony, it is an individual duty on whomever undertakes it and is asked to testify in consideration of what Allah exalted be He says, and do not conceal testimony, for whoever conceals it, his heart is indeed sinful. Surah Al-Baqarah, ayat 283. That is, when one is asked to testify of what one has witnessed, one is not to conceal testimony nor overstate in declaring it, since Allah says, for whoever conceals it, his heart is indeed sinful. That is to say, the heart of the one concealing testimony is wicked, a severe divine threat of turning one's heart into a wicked, disfigured one. Allah mentions the heart is in particular, since it is the position acquainted with what one has witnessed. The above verse signifies that testifying is an individual duty upon whoever witnesses an event whenever she is asked to testify. The great scholar Ibn al-Qayyim, may Allah have mercy on him, says, undertaking and declaring testimony are on obligation to non-performance of which is a sin. He adds, by means of analogical deduction of the view maintained by the Hanbali scholars in this concern, if the witness conceals his testimony, i.e. refuses to undertake or declare testimony concerning any right, he is to readdress this right in the form of a fine. This is because he has been able to give the right to whom it is due by declaring testimony, but refrained. It is as if one has had the opportunity to save a person from a dangerous situation, yet one has not done so.
So it's surely the importance of the person to give a testimony, and not for the person to conceal it or hide, but if it is required that a person go forward and to give that testimony, as you mentioned, that it falls within what is referred to as al-amr bil-ma'ruf wa nahi anil munkar and the likes. Aywa.
If there is no harm on the side of the witness because of declaring testimony, it then becomes obligatory upon him to testify. However, if testimony will cause harm to him personally or his sense of honor, property or family, in this case, it is not obligatory upon him. This is according to what Allah exalted He says, "Let no scribe be harmed or any witness." Surah Baqarah, ayat 282. This also is demonstrated in the hadith which the Prophet ﷺ says, "One should not harm others, nor should he seek benefit for himself by causing harm to others. And Allah exalted be He knows best."
So you mentioned a case of exception that in the case of a person being a witness, if he believes that being a witness, it may bring about harm to himself or his family or his wealth, then it becomes non-compulsory upon them to give that testimony. But they are ruling that he should give testimony. But if there's going to be harm that will come from it, then it's something a person can reconsider. Aywa.
The witness must be certain about the matter concerning which he is to testify. It is prohibited for the witness to testify to having witnessed anything except what she knows with certainty, by seeing or hearing, for example, in consideration to what Allah exalted be He says, "And do not pursue that of which you have no knowledge." Surah Al-Isra, ayat 36. And His statement, "By only those who testify to the truth can benefit, and they know." Surah Az-Zukhruf, ayat 36. That is, the witness must be
36.
Ayat 36, yeah.
And we have Isra 36,
Isra 36 and
Zukhruf
Zukhruf 36 as well, yeah.
36.
Yeah.
But in my book it says 86.
Oh, this one must be wrong.
So to be double checked,
Okay.
that matter regarding which ayah. There you are.
That is, the witness must be wholly certain regarding what she is to testify. In this connection, Ibn Abbas radiallahu anhu narrated, when the Prophet sallallahu alaihi wasallam was asked about testimony, he said to the inquirer, "Do you see the sun?" The man replied in affirmation. He sallallahu alaihi wasallam then said, "So testify like this or leave it," i.e. be wholly certain regarding what you are testifying, the same as you are certain of seeing the sun, or do not testify. This narration is related by Al-Khalal in his book entitled Al-Jami, the collection. Al-Bayhaqi says this narration is not narrated by a reliable chain of transmitters. However, Al-Hafiz ibn Hajar says, commenting on this hadith, but the meaning of the hadith stated in this narration is correct. To illustrate, knowledge about the matter regarding which one is to testify should be based either upon hearing it or upon seeing it. Thereby, one is not to testify to having witnessed anything except what one knows with certainty by way of seeing or hearing, or through hearing about an issue which is a public event discussed among people and which is difficult to know except in this way. And as in cases like relationships by marriage and death of a person. However, one is not to offer testimony depending upon hearing about an issue discussed among people, except when it comes to one's knowledge through a number of people enough to prove the certainty of such matter.
So regarding the mention of being witness to the person, that should be based upon ilm, that a person which is either the person have heard or seen that thing. So either something the person have seen themselves, or a person of so seen and heard that thing, then a person can go forward and give witness, or something that they have come by knowledge of that thing, but it's something which is widespread and commonly known by all and have been transmitted to him. Then in those cases, they can be witness to those matters. Aywa.
There are 6 conditions to be fulfilled by the one who is to deliver testimony.
So let's concern the person wish now to give the shahid, that these are the criteria they should fulfill. So the shahid, the person giving witness, they should fulfill these 6 criteria. Aywa.
1. Reaching puberty. Testimony is not acceptable from children except when it concerns matters relating to them. In this concern, the great scholar Ibn al-Qayyim says, the companion of the Prophet ﷺ and the faqirs of Medina used to accept the testimony of children when it is related to quarrels occurring amongst them. This is because men are not typically present at such situations. If the testimony of those children were not to be acceptable in such situations, people's rights would be lost, unfulfilled, and thus regarded, especially when the testimony is more probable to be to be truthful or reliably truthful. This is as in cases such as when they come directly without going to their homes to testify to an incident they have witnessed, agree on the same information, and are separated at the time of delivering the testimony. When their testimony is identical in such a case, their testimony is considered more reliable than that of two men. This is a view that cannot be denied or refused.
As I mentioned regarding those conditions, regarding the shahid giving testimony that one bulugh above the age of puberty, so that's, they mentioned that as for a child, between themselves, yes, but as for a child being witness against an adult, then no. So the testimony is not taken against an adult, but between themselves as children, then yes. As mentioned by Ibrahim an-Nakhai. Aywa.
Number 2, sanity. The testimony of the insane or the foolish person is not acceptable. As for the one who sometimes loses consciousness, his testimony is acceptable when he regains consciousness and assumes the responsibility of testifying. This is because in his consciousness, it is a testimony from a sane person who resembles a person who has not lost his mind.
Hey, so the next country they mentioned al-aql, so the person must be of sound mind. So the person said to be majnoon, and in that type of state, then their testimony is not taken, as they themselves. So they mentioned that they themselves can't be even a witness to themselves. They can't be a witness against themselves because they are majnoon. So against others, then this has been bab al-awla, even more so. That's the second condition.
Number 3, the ability to speak. The testimony of the mute is not acceptable even if his signs and gestures are understandable, since certainty must be fulfilled in testimony. The signs of the mute, in spite of that, are effective and sufficient in rulings pertaining to his affairs, such as marriage and divorce, for necessity. However, if such a person writes his testimony, it is then acceptable, for writing is suggestive of speech, i.e., what he cannot say can be written.
Then ulama mentions that they can be taken regarding the one who's unable to speak if they have signs that could be understood. So if giving signs, which we have today's sign language, so more established in today's time, that those who are unable to speak but they can with sign language and could be understood, then it is taken. It can be taken. Aywa.
4. Being a Muslim. A witness must be a Muslim according to the verse in which Allah exalted be He says, and bring to witness 2 just men from among you. Surah At-Talaq, Ayat 2. Thus, the testimony of a disbeliever is unacceptable except when being a witness to a will at the time of bequest, when one is traveling and one is about to die. Only in this case, the testimony of 2 disbelievers are acceptable when there are no Muslims. In consideration to what Allah exalted, He says, O you who have believed, testimony should be taken among you when death approaches one of you at the time of bequest, that of 2 just men from among you, or 2 others from outside, if you are traveling through the land and the disaster of death should strike you. Surah Al-Ma'idah, Ayah 106. The testimony of 2 disbelievers is legalized for necessity only in this case.
So general concern, the kafir, the disbeliever, their testimony is not taken except for 2 cases. What are they? Upon death and
For traveling.
wasiyah. So the person who wishes to make a will and he's traveling and there's no Muslim present, then they can use a non-Muslim, 2 non-Muslim as witness. Aywa.
5. Having a good memory. The testimony of a foolish or forgetful person is not acceptable, since it is known that such a person makes many mistakes and usually forgets, and because he is unreliable in telling the truth. Besides, whatever he says is thought to be incorrect, since it may be one of his mistakes. Yet testimony is acceptable from the person who makes fewer mistakes and does not usually forget, since none is free from both defects.
So the person hif, would they say adopt in the ulama al-hadith, or hif, that a person also that in his memory should be precise or can recollect what you have seen or heard as you have heard it and seen it. But I mentioned that so the person who makes a lot of errors is known to make a lot of errors, then his testimony is not taken. But it doesn't mean that no one is free from errors. Doesn't mean that anyone is free from errors. So, but a person does it a lot, then his testimony is not taken. That's the fifth that they mention.
6. Uprightness. Jurisprudently speaking, the term uprightness refers to one's righteousness and moderateness, whatever one says or does. What proves the uprightness is one of the conditions of testimony is what Allah exalted be. He says in the glorious Quran, from those whom you accept as witnesses, Surah Al-Baqarah, ayat 282, and bring to witness 2 just men from among you, Surah At-Talaq, ayat 2. The majority of Muslim scholars maintain that uprightness is an additional characteristic to being a Muslim. A just and upright Muslim is the one who abides by the religious obligations and acts of worship, observes the desirable deeds, and keeps away from committing the prohibited and detestable ones. In this regard, Ch.6. Ibn Taymiyyah, may Allah have mercy on him, says, the faqirs uniformly agreed that the testimony of the one known to be untruthful is rejected. Ibn Taymiyyah also adds, the concept of uprightness is valued according to each age, place, and people. Thus, a witness must be an upright person according to his own people, though the uprightness of the same person may be viewed differently by other people, though still considered uprightness. This is how judgments can be conducted among people. Otherwise, if testimony is restricted to those witnesses who establish the religious obligations and abandon the prohibited matters, as done by the Prophet's companions, then all the testimonies or most of them would be invalid.
Okay, so I mentioned the next of those points, the sixth said adala. So adala, that is being discussed, which is defining adala. We find a khilaf between the ulama as to, or different wording of the ulama as to how they define adala. But adala goes back to one, the person's level of istiqamah upon his deen, and also the person's character. So adala, it goes back to 2 things. The level of the person's commitment to Islam, and second, the person's character and behavior. Those are things that are used to decide as to the person adala. And Ibn Taymiyyah that mentioned that the adala of a person, it may change, or the standard may change from one time to another. So the adala of the Sahaba and the first 3 generations would not be compared to us in this century, as their standard is much higher compared to the people of our time, contemporaries. Aywa.
Ibn Taymiyyah goes on saying, it is advisable to accept the testimony of those known to be outwardly truthful in cases of necessity, even if they do not observe the limits set by Allah. Thus, their testimony may be accepted in cases related to imprisonment, incidents among Bedouins, or in villages where there are no upright witnesses. Faqirs, may Allah have mercy on them, maintain that one's uprightness is known by 2 things, the first of which is performing the religious obligations, the 5 obligatory prayers, and al-Jummah, Friday prayer, along with their stressed supererogatory practices. Thereupon, the testimony of the one regularly neglecting these prayers and the witr prayer is unacceptable. Concerning the one who persists in abandoning the supererogatory acts of prayer, Imam Ahmed, may Allah have mercy on him, says, such a person is a wicked one, for his persistence makes him a non-observant of the Sunnah out of reluctance, and so he is always blamable. Uprightness is also considered through avoiding prohibited acts, the same as it is considered through observing religious obligations. Thus, such an upright person should not commit the major sins, nor persist in committing a minor one. Furthermore, Allah has forbidden Muslims from accepting the testimony of the slanderer, the one who accuses a chaste person of committing adultery or fornication without producing 4 witnesses. Likewise, by means of analogical deduction, everyone who has committed a major sin is to be treated the same as the slanderer. Jurisprudently, a major sin is the crime which deserves executing a prescribed punishment in this world, or is severely threatened against in the Quran or the Sunnah with a punishment in the hereafter. These sins are like taking usury, delivering a false testimony, zina, robbery, drinking intoxicants, and other sins. Thereby the testimony of the defiantly disobedient person is unaccepted.
So the mention here regarding adala, that the author Hafidullah Ta'ala tried to discuss the matter further regarding adala, the person's level of uprightness. What I mentioned that is in two types, or two things will be factored in. The first you mentioned here, ada al-fara'id, that a person that committed to carry out those things which is fara'id. They mentioned, for example, salawat al-khams wal-jum'ah wa bi sunaniha الراتبة. They mentioned فلا تقبل شهادة من دام على ترك السنن الراتبة والوتر. So the ulama mentioned, they mentioned aqwal of Imam Ahmed, that the same Ahmed regarding concern that the person who leaves away rawatib, the addition the salawat that are prayed with the compulsory. So he mentioned the person that who leaves away those things, that is not considered to be a person who is said to be of adala, trustworthy. But the ulama of those somewhat does not per se agree with Ahmed regarding this matter. So leaving, they said that the journal says leaving of the sunan acts, it doesn't make a person lose his adala, because those things are not compulsory. So the person who leaves away the sunan acts, then the person is not considered to be have lost his adala, but it goes back to the person doing leaving the person leaving away those things which is compulsory, or following a thing which is haram. But as far as leaving away thing which is, they mentioned mashru', then that doesn't necessarily remove the person adala. And they mentioned that the more correct view, that is the more correct view, contrary to what is stated or mentioned about Ahmed on this matter. Aywa.
The second sign by which signs one's uprightness is known is respectability, namely observing the good deeds and having the traits that beautify and adorn one's character and conduct, such as generosity, good manners, and neighborliness. It also involves avoiding whatever may dishonor oneself of the ignominious and ignoble things, such as singing and comic acting. In this concern, Ch.6. Ibn Taymiyyah says, it is forbidden to imitate people sarcastically, and whoever does so, orders someone to do so, is to undergo discretionary punishment, since it is a harmful act. By means of analogical deduction, this applies to the TV series presented nowadays. How strange it is to consider singing nowadays as an art whose performers are supported and praised, and there is neither might nor power except in Allah. Whenever these aforesaid impediments preventing the acceptability of the testimony cease to exist, the testimony becomes acceptable. Hence, when the child reaches puberty, the insane person regains sanity, the disbeliever embraces Islam, and the defiantly disobedient person repents, the testimony of any of them is to be accepted. This is because there are no impediments as the conditions of the testimony are fulfilled, and Allah exalted be He knows best.
You mean that Sheikh Sa'd Khatlan, that he had a little taliq or a little comment on this particular discussion regarding that a person that after making tawbah, or a person that was involved in a thing which was haram, then makes tawbah. At what point can you accept that tawbah from them? With me? So the person did something or was involved in certain things, but then the person wants to make tawbah. At what point can you accept their tawbah? The person accept Islam. So the person before was not a Muslim, then accept Islam. At what point you can accept that as a genuine tawbah from the person? So you mentioned regarding concerning this matter that of the fuqaha, that what they consider regarding the person tawbah being considered to be the tawbah of a fasiq, islah al-amal, that a person, that you ever see the person doing righteous stuff. So the person that says, so go back to that, is not just making claims. The person said, I make tawbah, astaghfirullah, but he's not doing anything different. But he's saying astaghfirullah. But in his act, in his behavior, things hasn't changed. So the person wasn't, just said, the person stopped praying. Then it's tawbah for you to keep that seat as genuine. The person, now you see him praying. The person doesn't fast. Said, no, astaghfirullah, I'm going to start fasting. Until you see him fasting, then you believe that then that's a sign of him or her being genuine. So at times, regarding a person tawbah, it requires that you have to see signs that a person have left, do opposite to what they were doing before, for you to see it as being genuine. Because I mentioned that in a person, anyone can say, I make tawbah for that, but then there's no improvement, no change. Then that's just kalam. That's just kalam. That's the person speaking. So I mentioned that it requires the person have to carry out, do opposite to what they were involved for it to be considered to be genuine or valid. That's just a point. أيوة.
The testimony of the following is legally unacceptable. A person testifying in favor of his parents and forefathers and on up in ascending lineage, or in favor of his offspring and on down in ascending lineage. This is because one's testimony then is doubtful due to being a relative of the litigant one testifies for. However, testimony is acceptable from a brother for his brother and from a friend for his friend, according to the general meaning of the verse related to such an issue, and since testimony is then not doubtful. The testimony of a spouse for the other is unacceptable, for each of them is already obtaining benefit from the other's property, and also because of the close relationship combining both. All this makes their testimony in favor of each other doubtful. However, testimony at the same time is acceptable against one's spouse, in consideration to what Allah exalted be He says, "Be persistently standing firm in justice, witnesses for Allah, even if it be against yourself or parents and relatives." Surah An-Nisa, ayah 135. That is to say, if one testifies against one's parent, child, wife, or the latter testifies against their husband, the testimony in this case is acceptable.
It's the case regarding that, that they mention here that family members and also those who are close and related, husband and wife, spouses, testifying against each other. At times it's unacceptable, and at times it could be accepted. So at times it's unacceptable, and at times it's unaccepted. So they mention, for example, they meant this: if a husband and wife during their marriage, then I said not at times accepted. But for example, they got divorced. So they were married before, then they got divorced. Would their testimony be used against? Can be used against? Used? Can one testify for the other? Husband and wife divorcees. Abdullah says no. Of those who say no, that they cannot be used, their testimony for each other, because they were married before, and it continues even after divorce. But of those who mention it can be used. So after separation, of those who mention that it can be used, so it goes to a removal of this tuhma. If there's nothing that is there that may put some doubt on the matter, then it can be used. And also a brother against his brother, also that testimony can be used, as Umar mentioned at an ijma. Ibn Mundhir mentioned regarding a brother testifying for his brother, it is the ijma that it can be used. Aywa.
The testimony of a person that may get him some benefit or spare him some harm is unacceptable.
As I said, with a conflict of interest. So in cases regarding a person being tested to something where there's personal benefit, direct personal benefit to be gained, which sometimes can be a matter of conflict of interest, so the person cannot be a witness or participate in that thing. Aywa.
The testimony of a person against his enemy is unacceptable. In this regard, the great scholar Ibn al-Qayyim says, the Sharia has decreed that testimony is unacceptable when borne by someone against her enemy, lest testimony be used as a pretext to gain benefit or avenge oneself from one's enemy through perjury. Animosity, which renders one's testimony unacceptable in the case of being happy when another person is in adversity or sorrow, or unhappy when he is in prosperity or joy. It is worth mentioning that the animosity meant here is the worldly one, unlike animosity in religion.
So now two types of adawa. In this case, one which is influenced by things of the dunya. So you have the type of adawa, animosity or enmity between individuals based upon things of the dunya. Then also you have enmity based upon things of ad-din. So how to put them in perspective, Aywa?
Thereby the testimony of a believer against a disbeliever is acceptable. Likewise, the testimony of one following the sunnah against an innovator in religion is acceptable, since Islam enjoins Muslims not to commit whatever is prohibited. In addition, the testimony of a person known to be a bigot and of extreme zealotry for his clan is not to be accepted.
It's asabiyya, so the person of the asabiyya, that there's this fanatic partisanship to particular either person or a group. That's a fanatic, aywa.
Since his testimony would then be doubtful. The number of witnesses differ according to the case or issue testified in. If testimony concerns a case of zina, adultery or fornication, or sodomy, it is not accepted unless there are 4 male witnesses, as Allah exalted be He says, and why did they who slandered not produce for it 4 with ease? Witnesses. Surah An-Nur, Ayat 13. Since Muslims are ordered to conceal the faults of their Muslim brothers and so the faults of those committing any of those sins, the number of witnesses is 4 males.
So they mentioned, so the next thing that they discuss, after discussing the topic before, which is those people who are said to be qualified to be witnesses and those that may be disqualified. So after clarifying those that matter, then it goes to the next matter, which is adad al-shuhud. How many people are required to be witness? It varies from one act to another. It varies from one thing to another. As I mentioned, the first case of the case of the person concerned, the case of zina, lawat, so people involved in zina, fornication, adultery, or people who have intimacy with someone from the same gender. Now, so I mentioned that the amount of witnesses is 4. Aywa.
When testimony concerns proving the insolvency of a person known to be wealthy but claiming the opposite, then it requires 3 male witnesses according to the hadith related by Imam Muslim, in which the Prophet ﷺ says, until 3 wise persons from among his people witness that so and so, i.e. the person has been smitten by poverty. If testimony concerns the prescribed punishments for crimes other than zina, such as the prescribed punishment for slander, drinking intoxicants, robbery and banditry, or if it concerns qisas, legal retribution, then it is valid to accept the testimony of only 2 male witnesses. Also in such cases, women's testimony is unacceptable.
And so you mentioned regarding as not the case, a person may claim that they are going through poverty or going through financial difficulties, that if the person making such claim and they want assistance, that at times if you need witnesses to validate their claim, then you need 3 witnesses. Then I mentioned that in cases in general regarding for the hudud, for the punishment to be applied to a person, that the normal amount of people required is 2, except in the case of zina, which is how many? 4. Then I mentioned that in these matters regarding hudud, concerning that the testimony of women, they are not taken. They are not taken. Aywa.
If testimony concerns matters other than the prescribed punishments or financial affairs, which men often see or witness, such as marriage, divorce, or remarriage to one's irrevocable divorced wife, then 2 male witnesses may testify. Ch.6. Ibn Taymiyyah and his disciple Ibn Qayyim, may Allah have mercy on them both, maintain that if this testimony concerns remarriage with one's revocably divorced wife, then women's testimony is acceptable, since it is easier for them to be present at that time than at the time of writing the documents, i.e. marriage or divorce contracts. If testimony concerns properties and transactions related thereof, such as sales, renting and the like, then 2 men or a man and 2 women are to testify, for Allah exalted be He says, and bring 2 witnesses from among your men, and if there are not 2 men available, then a man and 2 women. Surah Al-Baqarah, ayat 282. The text of this verse signifies that testimony here concerns financial affairs.
Aywa.
So how do you deal with situations that only involve women's issues in a specific transaction?
If a woman, then hey, that's not a problem. If it's business, so a woman can be used as witness in transactions.
Between themselves?
Between themselves or even with men.
No, but it just mentioned that you can't take the...
It mentioned that two women in Mal, that two women...
The example before, so if it says women can't...
That's because no hudud, matters regarding hudud.
Yeah, so, and that's what I'm saying, so imagine...
Oh, hudud you're talking about?
Yes, so
okay.
imagine a thing that occurred, which was hudud...
And the woman,
only between women, and only women, sorry.
Sometimes if something happened between, and just only said the witnesses are only female of whatever happened.
Whatever happened just amongst females.
Sometimes whatever the issues that have occurred where they are the only witnesses, then it can't even said if matter regarding hudud, then maybe the judge may use concerning as the punishment if they are correct, ta'zir. So you go to what is next below, which is yes, that's still a form of punishment, but not to the more severe extent. Clear?
The contents of this verse signifies that testimony here concerns financial affairs. The great Muslim scholar Ibn al-Qayyim, may Allah have mercy on him, says, Muslim scholars uniformly agree that if testimony concerns financial affairs, then a man and two women are sufficient as witnesses. The same applies to transactions related to financial affairs, such as sales on credit, the choice to conclude a sale or to cancel it, mortgages, granting properties through wills, gifts or endowments. This also applies to the case of guaranteeing a property or spoiling it, the claim of slavery of one of unknown lineage, defining the amount of dowry or the recompense of the khul, a wife's release for payment. The wisdom behind accepting the testimony of women in financial affairs, Allah exalted be He knows best. In that is such transactions both men and women often witness them, whereupon the Sharia allows men and women to testify in such affairs. Allah exalted be He has stated that a man's share equals that of two women in many rulings, such as testimony, inheritance, diya, i.e. blood money, slaughtering for a newborn child, and emancipation. Allah exalted be He has demonstrated the wisdom behind this in His statement in the glorious Quran, so that if one of them, i.e. the women, errs, then the other can remind her. Surah Baqarah, ayat 282. That is, if either of the two female witnesses forgets any of the details of what she has witnessed, the other woman may remind her. This is because women by nature tend to forget, which renders the testimony of two women equal to that of one man. Yet if the testimony of a woman were to be wholly unacceptable, this would lead to wasting many rights and rendering them ineffective. That is why a woman's testimony is added to that of another woman to remind each other in case of any of them forgets. Besides, if testimony concerns financial affairs, it is sufficient for the plaintiff to have a male witness together with taking an oath. This is based on the hadith in which Ibn Abbas radiallahu anhu said, the Messenger of Allah sallallahu alayhi wasallam decreed that testimony concerning cases involving financial affairs is acceptable of a male witness together with the oath of the plaintiff, related by Imam Ahmed and other compilers of hadith. In this concern, Imam Ahmed, may Allah have mercy on him, said, it is stated in the Sunnah that a judgment can be based on the testimony of a male witness along with the oath of the plaintiff. In this connection, Ibn al-Qayyim said, this ruling accepting the testimony of a male witness along with the oath of the plaintiff in financial affairs does not contradict the hadith in which the Prophet ﷺ says the oath is to be sworn by the defendant. What is actually meant here is that if the plaintiff does not have any witnesses or proof substantiating his claim, then the case is not to be decided in his favor. However, if the plaintiff has an upright witness or the like, the case is not to be decided in his favor unless he is to introduce a male witness to support his claim along with taking an oath. If testimony concerns things that men do not often see or witness, such as concealed female defects, virginity, being deflowered, menstruation, childbirth, breastfeeding, participating in the childbirth and the like, the testimony of an upright woman is acceptable. This is according to the hadith narrated by Hudayfa, may Allah be pleased with him, who said, the Prophet ﷺ accepted the testimony of a midwife, related by Ad-Darqutni and other companions of hadith. Yet some scholars have viewed this hadith as a weak chain of transmitters. It is worth mentioning that it is stated in the two Sahihs that the Prophet ﷺ accepted the testimony of one woman in rulings pertaining to breastfeeding.
And that's the end of? Yes, alhamdulillah. So that's, we did our 10 pages.
But you know what, so I miscounted last time, it was 30 pages we need to do. But we done 15 though, alhamdulillah, yeah.
Okay. Okay, طيب. So inshallah, so that's concerning this particular bab that he discussed some of the matter that relates to ash-shuhud, so the criteria regarding those who are said to be witness, that those who are, what are the conditions for the witness, and also different type of how many witnesses are needed depending on different cases. So I mentioned earlier that a matter that relates to women in particular, that you need to confirm certain things, but particular to women, then just one woman that is just an upright, or one just woman, then that is sufficient. You don't need two, you just need one. You might have a case where a sister making a claim of something, but because of you cannot see, look at her, they might ask another woman just to verify the information. So if those things are, if you don't need one woman to verify, and that's sufficient as a witness. So that inshallah ta'ala, we have covered what is said to be, what is mentioned as matters regarding ash-shahada. So that inshallah ta'ala will end for today, and try to finish what remains next week. Wa billahi ta'ala tawfiq. So we can finish. So we can start 6:30 next week. Okay.